The state of Hawaii has a history of antagonism against the Second Amendment and the people's right to keep and bear arms. For years, the state of Hawaii made it almost impossible to obtain a license to carry a firearm. 4 years ago, however, this court held in New York State Rifle and Pistol Association v. Bruin that the Second and 14th Amendments protects the right to carry handguns outside the home for self-defense. Hawaii responded by replacing its old law on carry permits with new laws that achieved a similar result. At issue in this case is a Hawaii law that prohibits firearms on private property open to the public without the express and affirmative consent of the property owner. Who gets to decide when someone is allowed to carry on your private property, you or the state? Now, according to the Hawaiian legislature, people need express affirmative consent from the owner to carry on their property. This means before you walk into a convenience store, doctor's office, or even a parking lot, you need express affirmative proof that you have the owner's permission. Now, express is that which is express, is laid out in words. And affirmative means averring a fact to be true, that which is opposed to negative. Now, imagine requiring proof you have permission to enter a business open to the public. What if they don't like the saying on your t-shirt, or the color of your pants, or the fact that you have a child in a stroller? Yes, private property holders can deny access in any of these cases, but nowhere does a legitimate government require proof of permission to exercise your freedom of speech, press, or liberty before entering a publicly accessible location. Hawaii's new rule imposes severe restrictions on the daily activities of residents who have satisfied the state's rigorous requirements for the issuance of a carry permit. When these permit holders leave home, not only must they take care to avoid all territory where the possession of a gun is prohibited outright, but they must also be barred from entering any places that people routinely visit in the course of their daily routines, such as gas stations, restaurants, and stores. This law flips the default rule at common law, under which anyone has an implied license to enter property held open to the public unless the property owner withdraws consent. No one is saying that property owners cannot prohibit those carrying firearms from entering their property. All they have to do is post a sign at the entrance with the infamous no gun image. However, what Hawaii is trying to do turns public access upside down, but only for those who exercise their rights under the Second Amendment. In District of Columbia v. Heller, this court held that the Second Amendment protects an individual right to keep and bear arms, with the amendment's central concern being the fundamental right of self-defense. Heller instructed courts to ascertain the scope of the right by looking to history and emphatically rejected an ahistorical judge-empowered interest-balancing inquiry. So, according to the court, the central concern of the Second Amendment is the right to self-defense. That's partially true, since the Second Amendment also clearly states that a state's militia is necessary to its security. Now, petitioners, 3 residents of Maui County who possess concealed carry permits, and an organizational plaintiff with members who have such permits, filed suit in federal court seeking temporary and permanent injunctive relief, contending that the law at issue violates their constitutional rights. The district court enjoined enforcement of the law as applied to private property open to the public, but the Ninth Circuit reversed that injunction. Now, 3 resident petitioners sued in federal court, claiming Hawaii's law violated their rights protected by the Constitution of the United States. Personally, I think there's more to this case, but let's start with what the court found.